All right, we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. This morning's sessions are being broadcast via Zoom and also by YouTube live. My name is Jeffrey Kinder. I'm also joined by Justice Eric Neyman and Justice Edward McDonough. We will be the panel on all 6 cases on for hearing this morning. We will proceed much like we would in the courtroom. Each side will have 15 minutes to argue. There is no rebuttal. We have read your briefs and the record carefully, so I would urge you to get to the heart of your argument rather than dwelling on the facts. Should there be a technical problem of any type requiring a suspension, just bear with us. We will try to be back to you as soon as we can, but our experience has been pretty good with Zoom, so we expect that that will not happen this morning. This is 19P 1153, the Commonwealth versus ALEXEI KOUVCHINOV. Mr. Malkiel, when you're prepared, you may proceed.
Thank you, Your Honor. May it please the court. My name is Yakov Malkiel, and I represent the defendant appellant ALEXEI KOUVCHINOV. With me is Kevin Bolin in a separate window. And we ask the court to vacate the conviction and to reverse the order on the motion for costs. We present, as you know, a series of arguments for those requests in our briefs, but today I would like, if I may, to focus on 3 narrower points of clarification. And those relate respectively to the jury instructions issue, to the suppression issue, and to the court's assessment of whether any one of the errors requires reversal separately or cumulatively. Starting with the jury instructions issue, the defendant preserved an objection to the trial judge's decision not to instruct the jury on defense of another. And such an instruction is required if any view of the evidence supports it under decisions such as Commonwealth versus Miranda. If we take a close look at the trial judge's reasoning and at the Commonwealth's reasoning in its brief, we see that they both share a simple error of law. And that's in their assumption that the focal point of the analysis should be on the intentions of the victim, that is, whether he had any intention of harming the third-party bystander. In this case, that was the defendant's girlfriend, Maya Ackman. And the reason that that's an error is that this court held in Commonwealth versus Green that even an unintentional danger stemming from the victim requires an instruction on defense of another. In that case, the defendant and the victim were described as enemies. The victim had a gun and he showed up at the residence where the defendant was located and he started shooting at the defendant. And there is no suggestion that the victim had any intention of causing harm to the bystander who was located there as well.
Mr. Malkiel, if I could just jump in on that point. As I'm sure you know, the test for defense of another, it's the use of physical force to protect another in only justified, quote, when it is in response to immediate and imminent danger to the third person. That's a quote from the McClendon case. What is the evidence before us in the record that there was an immediate and imminent danger to the third person here?
Thank you, Your Honor. In this case, the danger to the third person, Maya Ackman, stemmed, according to a view of the evidence based primarily on her testimony, from the fact that the victim, Stephen Roach, was holding a large metal and wood ice scraper over her head while angry, while agitated, and while, in her words, aggressive. And there was a danger, whether intentionally or not, that he would end up hurting her with that ice scraper. That is the danger that a view of the evidence suggested Mr. KOUVCHINOV arose to prevent.
The Commonwealth is arguing, and I do see some support in the evidence, that Ackman's testimony was that the victim's focus and actions were at all relevant times directed toward the defendant. You disagree with that?
Your Honor, I think it's arguable whether that is a fair reading of her testimony. She does say at various times that she felt Stephen was confronting and attacking us, namely her and the defendant, and the trial court should have considered that. But again, the importance of the Green case is that even if we would assume that Stephen was focusing his attention, his gaze, his words on the defendant, Ms. Rockman was in between the two of them. She was closer to Stephen, and she could have been hurt even inadvertently by this ice scraper, even if Stephen was only intending to harm Mr. KOUVCHINOV.
Well, let me jump. Forgive me, Judge. Just one quick follow-up, and then I'll get quiet. As you know, your client interposed a defense of self-defense.
Yes, sir.
And accepting your premise that there was a focus on both him and the woman, the jury, as you well know, rejected his self-defense claim. And isn't that somewhat inconsistent with a claim that that there was evidence to support the defense of another if the jury rejected his own self-defense claim?
Your Honor, in this case, given its facts, I do not believe that's inconsistent. And in that respect, this case is different from Commonwealth versus Green, as we explained in our reply brief. And the reason for that, first, if you consider Green, the problem there for the defense was that the defendant was being shot at. There was absolutely no question that he was in danger. And the rejection of his self-defense theory necessarily meant, according to this court, that the jury did not believe the danger had anything to do with his actions. He was acting because he wanted to kill his enemy, or at the very least, he was using excessive force. In this case, on the other hand, it was quite reasonable and plausible for the jury to conclude that Mr. KOUVCHINOV himself did not believe that he was in danger, but did believe that Ms. Rockman was in danger. And there are at least two reasons for that. One is that Mr. KOUVCHINOV was simply farther away from Stephen, not necessarily within easy reach of his ice scraper. And second of all, the jury could hear both from the testimony and from viewing Ms. Rockman on the stand that the demeanor of the two people was different. Mr. KOUVCHINOV, I hope they'll forgive me for saying so, based on the testimony, was acting belligerently. He wasn't afraid of Stephen Roach. At least that's something that the jury could have concluded. Whereas Ms. Rockman was pleading with Stephen, according to the testimony, begging him to de-escalate the confrontation. And the jury could have concluded that Mr. KOUVCHINOV was afraid for her safety, even if he was not afraid for his own.
Mr. Malkiel, what about the timeline of Ms. Rockman's testimony? My understanding, and you can correct me if I'm wrong, is that she's testified to the effect that that the victim became detached from her, was sort of looking past her, and that then the victim said something to her to the effect of, "If I'm upsetting you, I'm sorry," and was sort of moved past her, and then the assault happened. Am I incorrect about my understanding of the timeline?
Well, I agree, except that the words "moved past her" are a little bit ambiguous. I agree that it appears from her testimony that at that point in time, Mr. Stephen was speaking towards the defendant in an aggressive way while apologizing to Ms. Rockman. And that's why I began by emphasizing the Green case, which shows that the focus of the victim, just like the focus of the victim in in the Green case, is not determinative. He may well be focusing on the defendant, Mr. KOUVCHINOV, but with Ms. Rockman in his way, she was in danger. And if I may add, one additional point showing that that's a scenario that the jury could have found, that they could have found that Mr. KOUVCHINOV was acting to defend Ms. Rockman, even though the victim was focusing his gaze and words on Mr. KOUVCHINOV, is that according to all of the testimony, as Mr. KOUVCHINOV jumped up and reached for the ice scraper, he simultaneously pushed Ms. Rockman out of the way. So that would have buttressed the viability of that theory for the jury.
I circle back to one of Justice McDonough's questions. Assuming for the moment that we agree that there was at least a foothold for an instruction on defense of another, in light of the fact that the jury rejected what arguably on this record was the stronger defense of self-defense, I can't quite grasp your argument with respect to prejudice.
Well, Your Honor, in the Commonwealth versus Miranda case, the court explains that there too, the request for an instruction on defense of another was preserved, and therefore the court reviewed for prejudicial error. And the court said the prejudice is obvious because the jury could have acquitted on that theory. And it's commonplace that juries are presumed to follow the instructions, and they cannot acquit a defendant on a theory that has not been presented to them, just as they are presumed not to convict on a theory that's not presented to them. For the reasons that I addressed earlier, in this case, it was certainly a plausible reading of the fact that Mr. KOUVCHINOV was not acting to defend himself because he was not concerned for his own safety, but was acting to defend Ms. Ackman because he was concerned for her safety. And that's a theory that the jury could have acquitted on if they had been instructed on that theory. And let me move, if I may, to my second topic, which is the issue of suppression. Under this court's holdings in Commonwealth versus Santos and Commonwealth versus Fletcher, cited in the briefs, reversal is required if a motion to suppress had merit and there's a reasonable possibility that suppression would have made a difference to the verdict. Now, in this case, the leading opinion for the type of scenario presented here regarding consent is Commonwealth versus Rogers. And a close look at the Rogers opinion and at the briefs in that case shows that not only the key facts, but also the state of the record in that case were identical to those here. And let me explain what I mean, if I may. In this case, the Commonwealth does not dispute that Mr. KOUVCHINOV had standing to argue for suppression. And it does not suggest that any exigent circumstances required or justified a warrantless entry into the apartment. They also do not disagree that the evidence that the officer provided based on his observations in the apartment was significant, such that suppression would have resulted in a reasonable possibility of a different verdict. The Commonwealth's only argument is that the record before the court is not adequate for the court to review the merits of the suppression issue. But if we look at the Rogers case, we see that the Commonwealth made the exact same argument there, that it had not had an adequate opportunity to develop the record on the issue of consent. That's in the briefs and in footnote 1 of the opinion. And the SJC easily rejected that argument. And the reason for that is that it's a simple set of facts that compels the conclusions the court reached in Rogers and which are applicable here too.
But in Rogers, there was a motion to suppress filed, correct?
That's correct. And
there was a record below on this issue, correct? In other words, there was a hearing, arguments were made, etc.
I apologize for interrupting, Your Honor. There was a suppression motion in Rogers, but the Commonwealth's point was that the suppression hearing had focused on an entirely different issue, namely the issue of apparent authority. And
I understand, and I'm going to interrupt you just so I can get my question out, which is, in the absence of a motion for new trial here, without the parties making the specific arguments and creating the record as to that issue, both legally and factually, it's very difficult for an appellate court to go down the road that you're setting forth and to make a finalized determination as to the merit or lack of merit on the issue. Isn't this a case that cries out for a motion for new trial and a hearing, which wasn't filed in this case?
Your Honor, certainly that is the general rule in most cases, that a motion for a new trial would be the first, the way to raise a suppression issue in the first instance. However, in cases such as this, the facts relevant to the determination of the suppression issue are all undisputed and all appear on the record based on the parties' development of other issues. And
Counsel, can I jump in on that point? But just on the state of the evidence that we have, the officer came to the apartment and The evidence, as I understand it, was that Ackman then pointed directly behind her to the defendant, and then the officer entered. Isn't that evidence of consent?
Your Honor, one might have thought so, but for the opinion of the Supreme Judicial Court in Rogers, where the exact same fact pattern occurred. The officer arrived at the apartment, did not ask for permission to enter, did not explain that he was intending to effect a search or a seizure, but simply asked about the defendant's location. And the person who'd opened the door pointed in the direction of the defendant. And what the court held was that that is an insolubly ambiguous action, does not ambiguously show consent. And in any event, even if it did show consent, it would not show consent unfettered by a claim of coercive authority, which is what the Constitution demands. There is simply—
Counsel, even if trial counsel had raised this issue at the trial, to set aside for the moment the failure to file a motion to suppress, but even raising it at trial would have given the Commonwealth an opportunity to develop the evidence just on that point. So to Judge Neyman's point, how are we to assess the issue when the issue wasn't raised either before trial or even during trial? Isn't it too late?
Your Honor, I'll answer the question, though I see my time is about to be up. And I would suggest that this is one of those cases where the testimony provided simply covered all of the relevant facts, with or without a motive for the Commonwealth to address the issue. And therefore, the lack of a motive, just as in Rogers, really doesn't make a difference. All of the facts are in the record and they're available for the court to assess.
Thank you, Mr. Malkiel. I see your time is up, and if neither of my colleagues have questions, we'll move on to Mr. Lee.
Thank you, Your Honors.
No further questions. Mr. Lee, the floor is yours when you're ready.
May it please the court. My name is Chi Lee, Assistant District Attorney for Middlesex on behalf of the Commonwealth. In this case, the defense of another instruction was not warranted. A reasonable person in the defendant's position would not believe his girlfriend was under attack. As Justice Lemon pointed out, the defendant's girlfriend's testimony was the defendant became detached from the girlfriend and looked directly at the defendant. And Judge Cremens, who was the trial judge, also found in trial transcript volume 2, page 101, that she found specifically all the threats were directed at the defendant. That's the reason why she rejected defense of another instruction. And the records support that, and the Judge Cremens did not abuse her discretion in doing that.
Mr. Lee, was there evidence that the victim was holding an object above his head?
Yes. So according to the girl—
Let me just finish. I'm sorry. Was there evidence that Ms. Ackman was standing between the victim and the defendant while the victim held the object over his head?
Yes. So if you look at trial transcript volume 2, page 7 to 9, that's the relevant portion of this interaction. What happened was—
let me finish the third part of the question is, was there evidence at that time that the victim was threatening, acting in a threatening manner?
According to her, the victim was standing in front of the girlfriend and the defendant was sitting behind the girlfriend. And that's when the victim raised up the eye scraper above his head, according to Ackman, which is the girlfriend.
So here's my question. In light of all of those facts and those surrounding circumstances, why, viewed in the light most favorable to the defendant, does that not warrant an instruction for defense of another? Why? I understand you're saying that the threats were actually directed at the defendant, and we have the comment made by the victim, I hope I'm not scaring you, but couldn't the defendant from his perspective have felt that she was being threatened, or at least that she was in imminent danger, and he acted accordingly? Why does that not warrant an instruction viewed in the totality of evidence?
The key point there was the girlfriend testified all the threat. The victim became detached from her, and the fact that the victim apologized shows that under the circumstances, a reasonable person would not believe that the girlfriend was in danger. And even if the instruction was given, as Justice pointed out, in Commonwealth v. Green, because the jury rejected the self-defense instruction, and because defense of another instruction tracks self-defense instruction, the jury, even if given the instruction of defense of another, would not entertain that theory. So even if the instruction should have been given, there will be no prejudice in this case. And if you look at all the circumstances in this case, where the victim became detached from the girlfriend and apologized to the girlfriend, it shows that no threats was directly at her, and a reasonable person would not believe that she was in imminent danger. And move on to the suppression issue. Commonwealth v. Fletcher, as the defense counsel pointed out in his reply brief, the court there did review the stop issue, but the court there found that the stop was constitutional. That's the only reason the court upheld that stop. And for the first part in Fletcher, the court found that because there was no motion to suppress filed in that case, the Commonwealth had no occasion to support or to justify the freeze, and that's what happened in this case. If there was a motion for new trial, or if there was a motion to suppress, the Commonwealth could have all three officers who responded to the apartment to testify the scenario. The Commonwealth could also call the girlfriend to testify whether she knew that she could have not admitted the officer to in the apartment. In Commonwealth v. Volsing, which is 414 Mass 772, that's where the Commonwealth v. Rogers, the SJC, distinguished from Volsing. But in Volsing, the key point was the third party there, or the defendant there, was able to understand that he could or could not admit the officer. If the Commonwealth could develop that below, we could have easily justified the consent. And because the Commonwealth had no occasion to justify any action made by the officers, and their trial, there was no occasion raised by the defendant for the Commonwealth to justify that warrantless entry, this court should not entertain the defendant's ineffective assistance of counsel claim.
Lee, can I ask you a question about the denial of the motion for funds?
Yes, Your Honor.
The motion originally was made pursuant to Chapter 261, Section 27D.
Correct.
And as I understand it, that the law provides that a court should not deny a motion for funds without holding a hearing. Was there a hearing in this case?
There was a hearing. The original citation was for pretrial funds. That's why the defendant later moved orally to Rule 30C5, which is a post-conviction motion for funds. And there was a hearing in front of Judge Heffernan. However, the problem in this case was there was no affidavit from the doctor explaining whether she had sufficient facts and data, what kind of reliable method she's going to use. Basically, there was no information to show her testimony would have been admissible under Rule 702. And the judge acted in her discretion to deny the defendant's motion. But
do you agree as a general proposition that expert testimony regarding wounds and whether or not they are defensive is often the subject of expert testimony?
Yes, Your Honor, and it might be helpful, but we don't know if the doctor could actually give something helpful given the facts and data in this case. From the facts and data we have is the photograph of the victim's stab wound. And we don't know from the expert opinion whether she could render sufficient opinion based on that photo. If the doctor would provide some affidavit just explaining what's her method, and whether there's sufficient facts and data, the judge might have acted differently, but that's not the case here.
Isn't that a little bit of a catch-22, asking for an affidavit before the expert has had an opportunity to devote any time to it?
No, Your Honor, it's basically a preliminary not even a preliminary opinion. It's mostly just her qualification, whether she has done similar things before, what's her expertise, and whether if there's any reliable methods could be used in this case. If the scientific film is there's no way a doctor or an expert could examine the photo and render sufficient or helpful opinion, the Commonwealth should not spend $2,500 on an expert and rendering an opinion that's not helpful to the jury or to the court. So the motion was probably denied.
Are you stating that an affidavit is required as a matter of a rule of civil procedure or some other authority?
No, I would not say it's required, but under Rule 7C, 30C5, it is the defendant needs to establish the expert's testimony. Proposed testimony will be helpful to the judge or to the jury, and that evidence is admissible. And the affidavit would help to show that the proposed testimony would be admissible under Rule 702, which we have to show there was sufficient facts and data, there is reliable methods, and the doctor will use that reliable methods to the facts and data. And none of those happened in this case.
And was her CV submitted along with the motion or no?
There was no CV. The defendant did in his motion point out the doctor's
Her
education,
right.
Just her education, and that's it. Education and her occupation, but none of her publications or not her prior work. None of those were included. So there was no CV in this case. If there are no further questions, the Commonwealth rests on its brief.
Seeing none, thank you very much, Mr. Lee.
Thank you.
Thank you, counsel. Thank you all. The case is now submitted.
Thank you, Your
We are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court argument session this morning via Zoom. We are also live on YouTube. This case is 19P 1200, Commonwealth versus Jeffrey VELLUCCI. My name is Jeffrey Kinder. I'm joined by Justice Eric Neyman and Justice Edward McDonough. Counsel, we will proceed just as if we were in the courtroom. Each side will have 15 minutes to argue. There will be no rebuttal. We have read your briefs and the record carefully, so your time is best served, I would suggest, by Mr. Lovins. When you are ready, you may proceed.
Thank you, sir, and good morning to all the justices. The defendant's motion to suppress argued that the items seized, statements made, and evidence discovered or identifications made pursuant to the stop must be suppressed, being fruits of the poisonous tree pursuant to Wong Sun versus the United States. The motion to suppress should have been allowed because there was no probable cause for the restraint, and Miranda warnings were not provided.
Mr. Lovins, can I interject with a question? Do you agree as a matter of law that the fact that the defendant was placed in handcuffs does not necessarily mean that he was arrested?
Yes, sir, I do.
Right. If we credit the findings of the motion judge that the defendant lifted himself from his car and moved toward the officer, not complying with his commands to get back in the car, and did so in what was perceived as an aggressive manner, why doesn't that justify a temporary restraint?
Well, I think, of course, the question should be, was there a legitimate basis for a concern for safety? If there was a legitimate basis for concern for safety, then I would agree. My argument is that there was no legitimate basis because, number one, conduct of the defendant was really no different than conduct in most other OUI cases. Officer Halliday testified at trial that he had had more than 25 OUI arrests. I don't believe that he could legitimately argue that this conduct was much different than he had seen before. Furthermore,
isn't it a little bit unusual for a defendant to get out of his car and move in the direction of the officer and continue to move in that direction after being directed to return to his car?
No, not really, not in my opinion. I think you might get more than one answer on that, but I don't think so. This is an educated man who is of necessity an inquisitive person who I would argue is trying to inquire as to what it is that's actually going on. In addition, as far as safety is concerned, there were no weapons that were found on him during a pat down. There were no weapons found in the car. And this was unlike the case attached by the Commonwealth in its addendum. It was not a case where the police officer knew that a violent crime had been committed, and one where blood was actually found on the defendant. And so I don't really believe, I believe that a legitimate argument could be made that the safety argument, safety basis was manufactured. And so I don't believe that a legitimate safety basis exists. Of course, there are other good reasons for restraining the defendant if the officer was concerned with flight. The car, of course, was incapacitated and he couldn't leave by car. If we believe the officer, he was flailing around, and that's inconsistent with being able to take off and leave the scene.
Mr. Lovins, is the officer's decision to place the defendant in handcuffs, the reasonableness of that decision, is that a question of fact or a question of law?
I think since the examination in these cases is objective, I think it's a question of fact.
So if there is evidence in the record that the defendant got out of the car, was told by the officer to move back to the car, and he doesn't do so, the defendant continues to approach the officer with his arms flailing, and I know you take issue with the credibility of that, is told again to move back to the car and doesn't do so, where is the clear error in the judge's determination that the officer acted reasonably in handcuffing the defendant for both his and the officer's safety, particularly where the officer also testified that the defendant stumbled prior to the officer placing cuffs on him?
Well, again, it's a question of the objective reasonable man and whether or not it was reasonable for this officer to act in that fashion. I have been involved in a number of OUI cases where the conduct is really not much different, and honestly, it's actually very unusual for an officer to be cuffing a defendant based on that type of conduct. Now, I agree that it's not frequent that the defendant gets out of the automobile, but in this case, he did, but he certainly, I mean, I didn't get the sense that he was being aggressive towards Halliday. He certainly was being aggressive, meaning, as I understood it, coming forward. But then again, Halliday was being aggressive in his conduct for the defendant, which goes to the issue of whether or not this was an interrogation outside of the police department.
What does the evidence of the be on the lookout for a hit and run vehicle combined with the damage to the defendant's vehicle add to the calculus, if anything?
I think nothing, because both the BOLO, that is the the information from the BOLO, the smelling of the alcohol came after the cuffing of the defendant. Had it preceded the cuffing of the defendant, I would say that the Commonwealth would have a good argument that there was probable cause. I don't see that there was probable cause here. I don't see that there was a danger that was being created to Halliday or a danger on behalf of or for the defendant. The defendant wasn't injured. And so certainly that is not a basis for it. But again, I think that it comes down to a question of what the objective reasonable person would have done. And if the panel believing that this activity didn't rise to the level of the defendant needing to be handcuffed, well, then that's a different story.
Mr. Lovins, could I ask you to address the second part of your argument, that is whether or not the defendant was in custody for purposes of Miranda?
Yes. The case law suggests that there are 4 indicia for custody: the location of the interrogation, the police having suspected that the defendant, or communicating that the defendant was a suspect in a crime, whether the officer was aggressive in his questioning, and whether the defendant was seized. As for the first one, that is the location of the interrogation, you don't have to be in a police station for that to occur. In fact, there are cases, as we know, where interrogation has occurred in a police department. That still does not necessarily rise to the level of an interrogation. Here we have an interrogation being conducted close to midnight. No one in the area for Mr. VELLUCCI to reach out to. It's on the side of the road. This is a police cruiser. Of course, Mr. VELLUCCI has to have known that the police officer would have been armed. And this is in my view, a so-called compelling police atmosphere.
Mr.
Mr.
Lovins,
Lovins, do you agree that the record shows that the only questions asked of your client were, are you armed? What happened? What's going on?
Correct.
How were those questions accusatory rather than investigatory?
Well, I think when you add to the fact that I would agree, I don't think they are. On the other hand, I think when you add to the calculus that it's midnight, it's dark, VELLUCCI has nobody to reach out to for assistance, it's along the side of the road. You have this officer who is subsequently joined by other cruisers, and he has his police lights flashing at that time. And I would say that that would add to the calculus of making this an interrogation worthy of Miranda warnings. Number 2 is a communication that the defendant was a suspect in a crime. I think that was communicated simply by the cruiser pulling up behind VELLUCCI, because VELLUCCI knew that he had been involved in an accident. And I think the appearance of that cruiser communicated that what the police thought about that. The questioning, whether or not the questioning was aggressive, my opinion, it was, because it wasn't once where the officer told him to get back in the car. He repeatedly told him to get back in the car. And I believe that this was an aggressive And at the same time, he's asking him, what happened? Are you armed? I believe that is sufficient. Of course, no, you don't need all four of them, as I understand, and no one is more important than another. Finally, was VELLUCCI free to leave? And under U.S. versus Mendenhall, which is still the law in Massachusetts, as you know, and it's not California versus Hodari, under that standard, then the question is whether the defendant felt that he was free to leave. That's an objective standard also. And frankly, I've never understood how a defendant can be in handcuffs and believe that he is free to leave.
Is a defendant free to leave during any legitimate traffic stop? So in other words, if an officer pulls someone over for committing a traffic violation, walks up to the car and says, "What are you doing?" Is the defendant free just to take off?
Yes. I believe he is. I think
Can drive away.
that's what, yes. And if he does, then that may create the basis for him being pursued. However, he is free to leave. Yes, he is. Moving on to some other items I have. Let me see, what time do I have here?
Not much.
Excuse me?
Not much.
Not much, right? It always turns out that way.
And in fact, now, Mr. Levins, I note that your time has expired.
I see. It is.
Thank
you
you
for your attention. This was actually quite a good experience.
Oh, thank you, Mr. Levins.
Doing this on Zoom.
All right. Mr. Ferreter, when you're ready.
Thank you, Your Honor. Good morning. If it may please the court, Timothy Ferreter, Assistant District Attorney from Middlesex on behalf of the Commonwealth. I think this case illustrates the often fluid nature of police work, where the officer first pulled over to help what he believed to be a stranded motorist who was involved in an accident. When the defendant pulled himself out of the vehicle, stumbled on his way back to the police cruiser, yelling incoherently, I think that's when it became reasonable suspicion of operating under the influence. The officer appropriately responded by asking him to get back in the vehicle. When the defendant remained aggressive, wouldn't calm down, under Botari and Williams and Willis, there was a proportional and justified response by placing the defendant in handcuffs. There was both reasonable suspicion to do so, and it was proportional given the circumstances where the defendant was acting aggressively on the side of the road and he was alone with a police officer close to midnight. After the defendant was placed in handcuffs, the judge found that he quickly calmed down, and that's when the single question was posed to him: what happened? A simple question: what happened? What's going on? And that's when he made the incriminatory statement about drinking at the end of tax season. I think, given the four factors as laid out in Cothran, that this didn't raise to a coercive atmosphere requiring Miranda. In Cothran, the SJC clarified that free to leave is a factor, but not the determinative factor. And looking at the four factors in their totality, this was in public, not in the back of a police station, which was Miranda's main concern. There was no way it was conveyed to the defendant he was a suspect. It was a very simple investigatory Terry type of question: what's going on? There was no aggressiveness on behalf of the police officer. He testified consistently that it was his objective to get the defendant to calm down and to de-escalate the situation, which worked once he was placed in handcuffs. This is a very different situation than a case like Gordon, where the defendant had to be chased and tackled and handcuffed and placed in a cruiser before the question was asked.
Mr. Ferreter, can I just jump in before you get too far down the road? I noticed the judge made a finding that the car was facing in the wrong direction. I guess that would be so that when the defendant gets out of the car, he's walking directly toward traffic, if there is any traffic. I don't think the judge made any findings, but was there anything in the record about how busy a road this was? For example, is this a side street or is this a busy street? Because seems to me it would matter that if you've got somebody facing the wrong direction, getting out of a car and walking directly into oncoming traffic. But I just curious whether there was anything in the record that the judge decided not to note.
No one testified to it. I think, one of the issues, this is the next town from the district court in Lowell Street in Wilmington. You would know it's the main street, but it's not on the record. But I do think everyone in Woburn District Court would know that, but it's not on the record.
Okay. Thank you.
Speaking of the record, Mr. Ferreter, was there any indication of how long the defendant was handcuffed before the cuffs were removed after other officers arrived?
I believe it was minutes, because he said he was on handcuff when the backup officers arrived, and the backup officers arrived within a few minutes. I'd have to look up to get the exact site of that, but it was not long. And as soon as they asked if he would do field sobriety tests, the handcuffs were removed. But the question was already asked and the answers already given prior to the handcuffs being removed. And I pointed out Monahan, the unpublished decision, because it's the closest factual case I could find. But I think given all the factors, this is also a very similar case to Cothran, where the defendant was certainly stopped and not free to leave. But this was nothing more than a basic Terry stop based on reasonable suspicion, based on the combined factors of the accident, the aggressive behavior, the stumbling, the incoherent yelling.
Was the defendant also handcuffed in that case?
In Monahan?
Yes.
Yes. He was handcuffed. In that case, the officer said, "You're not under arrest. I'm handcuffing you until I can figure what's going on." Here, the officer didn't say that you're not under arrest, but he said, I'm handcuffing you for your safety and for my safety. He didn't tell me he was under arrest, but he also didn't, in fairness to the defendant, say that he wasn't under arrest. But it's also very different from some of the cases where Miranda was found, because it's not a case where there was pursuit, tackling, aggressive questioning, being placed in the cruiser. Everything calmed down pretty immediately after the defendant complied and put his hands behind his back and handcuffs were placed on him. But I think given the calm nature, the one question in public, it certainly doesn't rise to the situation that the Supreme Court was worried about in Miranda, which is the defendant in the back of a police station, cut off from the world, where the police are using aggressive tactics to overcome the will of the defendant for a long amount of time in this interrogation. This was one question in public on the side of the road, and it just simply doesn't raise the concerns that the Miranda court was worried about.
I agree with some of Mr. Lovin's comments about the free to leave standard. So I'm going to ask you the same question, which is, do you agree with Mr. Lovins that someone's stopped pursuant to a routine motor vehicle traffic issue, who's approached by the police officer and stopped on the side of the road, is free to leave?
I disagree with that. I don't think he is free to leave, but I don't think free to leave. I think Cothran, the SJC, was very insured in Cothran that they pointed out free to leave is not the standard, it is a factor, because the SJC and the Supreme Court have made it very clear that Miranda warnings are not required for almost any traffic stop and for most Terry stops, which would be a stop under the Fourth Amendment. But the Miranda warnings pursuant to the Fifth Amendment aren't required until you get to a level of a stop that's equated to a formal custody, a formal arrest, which just simply didn't happen when that initial question and incriminating statements were made.
And do you agree with Mr. Lovin's response to my question that the reasonableness of the decision to handcuff the defendant, ostensibly based on concern for danger, is a question of fact?
I think it's a question of fact and law. You have to take the facts and apply them to see whether it was reasonable under Otari. And I think in this case, the proportional response by the officer was reasonable, given the facts of this particular case. Most OUI stops, the person isn't handcuffed until they're arrested. But in this case, the defendant was acting aggressively. The officer tried to give a first proportional response by getting the defendant to sit back in his vehicle. He wouldn't do so. He continued to act aggressively. And I think the handcuffs were in a proportional and a justified response in this case. But it's still, despite that being handcuffed, it didn't rise to the level of Miranda custody, where everything quickly calmed down and there was brief interrogation on the side of the road. And if there are no further questions.
Seeing none, thank you both for your
Thank you.
arguments. It's been very helpful. The case is now submitted. In a few moments, Megan will.
We are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. All persons having anything to do before the Honorable. God save the Commonwealth of Massachusetts. Court is open.
Good morning, ladies and gentlemen, and welcome to this session of argument in the Appeals Court. Today's arguments will be conducted via Zoom and also will be live streamed on YouTube. My name is Jeffrey Kinder. I am joined by Justice Eric Neyman and Justice Edward McDonough in this particular case, which is 19P896, the Commonwealth versus Joseph Hennessey. We will proceed as we would in the courtroom. Each side will have 15 minutes to argue. There will be no rebuttal. We will from time to time interrupt with questions to help clarify your argument or points on the record. Please bear that in mind. Also keep in mind that we have read carefully your briefs and the relevant portions of the record. So I would ask you to focus on the strongest parts of your argument rather than on the factual background. With that, let me turn to Ms. Peterson for your argument on behalf of the defendant.
May it please the court. Good morning, Your Honors. I represent Mr. Hennessey, the appellant in this case. While this fact pattern may be abhorrent and repugnant to many, that does not make the statute available to stretch the meaning of the words to cover this fact pattern. As your justices know, we have to look at the plain meaning of a statute in order to make it fit the fact patterns of a case. This does not do so. The element number 5 is without that person's knowledge or consent. That basis goes to the subject being photographed, electrically surveyed, or videotaped in this case. It does not depend on the defendant's point of view. As we notice in Wasili, the purpose of the statute is to protect an individual's privacy rights and punish those that infringe upon those rights. In this case, the Commonwealth is taking a reasonable person standard, which the legislature did not mean to give them. This, if that was the case, it would have stayed within a disorderly conduct and accosting another person statute, 272-53, but it doesn't. Because,
Peterson,
yes, Your Honor.
if the camera was hidden in the flower pot in the bathroom, and the video showed that the camera was used to take photos of women's genitalia while they were going to the bathroom. And there's no evidence that any of the women knew of the camera within the flower pot because it was hidden. Why is it not a reasonable inference that they neither knew nor consented to this conduct or to being filmed as such?
Well, you know, I think it's perfectly put out actually in the defendant's brief, is that they don't have to prove, the Commonwealth does not need to prove it's with the subject's knowledge and consent. It's got to be without their knowledge and consent.
And why is it not reasonable to make that inference based upon the circumstances that I just stated, plus the reaction from the waitress who located the camera? Taking all of those factors together, why is it not a reasonable inference to draw that there was no consent and no knowledge?
Secrecy is not enough, Your Honor. That's only one of the elements. And while these fact patterns may overlap into different areas, secrecy is not enough. The reasonable person standard set out in number 4 is not enough. It's that number 5 element that gives the subject of this videotaping the consent or the knowledge. Otherwise, Your Honor, a defendant could say, I misunderstood. I thought I had their knowledge and consent, and therefore it would make it okay. That would fall into the trap of almost a rape case, Your Honor. The consent is personal to that person. And the
Counsel, if I
Yes,
may, I think I agree with you. There has to be some evidence that there was no consent, but why can't the absence of consent be proved entirely by circumstantial evidence? Because in every case that I understand, juries are instructed that circumstantial evidence is entitled to just as much weight as direct evidence. And so following on Judge Neyman's question, why couldn't the jury, based purely on circumstantial evidence, conclude that there was no consent?
Your Honor, I absolutely agree. The defendant's brief states that, you know, the defendant is looking just for direct evidence. That's not true. Of course, it can be proved through circumstantial evidence. But in this particular fact pattern, there isn't. The videos of these women that was presented to the grand jury, as well as to the jury itself during trial, is from basically the chest area down. There's no facial expressions. There's no bodily actions, as in they're looking away from the camera, or they're even directly staring at the camera, which the Commonwealth will concede. They never identified these women. The defendant is not saying someone had to come in and testify. That's not what we're saying. What we're saying is there's no circumstantial evidence even to put this within the realm. If the videos presented during trial, the ones 8 through 12, which showed the women's faces and clearly they had no idea what was going on, if those had been presented at a grand jury, that would give an indication the women did not know. But that's not what we have here. You know, we're not going to argue this conduct isn't repugnant. It's not abhorrent. But what we're saying is this is a very fact-specific case. And because the women and the subjects were not shown that they didn't have knowledge or consent, then that is something that lays upon the subject. It's not something that lays upon the knowledge.
Ms. Peterson, what I hear you saying is that absent filming and videotape that would reveal facial expressions, that the Commonwealth can't meet its burden of proof. Is that right?
I believe that's true, Your Honor, in this circumstance. I mean, like, again, this is a very fact-specific case. You know, Wasili states that, you know, it's an individual's rights that are being protected. A slip opinion actually came out regarding this. Unfortunately, but this is so new, there is not a lot of case law on this. But even Bark, which I mentioned in my brief, states, you know, the women did not know they were being secretly recorded. The woman found out afterwards. And then she said, look, he didn't have my knowledge. He didn't have my consent. But they could also look at the history that they had, which is not present here, of this woman and this defendant. And in that case, the woman said, yeah, I had taken actually pictures beforehand. She wasn't completely nude. But I said no at this point. I said, no, I didn't want it to happen. And the court found, you know what? It didn't matter what their history was. We looked at it, but you know what? What the defendant said, the jury was allowed not to believe him because the woman was shown in that videotape, obviously not wanting it to have it done. And yes, she came in and testified afterwards, but the defendant shouldn't be able to use as an excuse our prior history. And that's why they can do it. I think what the legislative intent was in this case was to give that power to the subject. Otherwise, if you take the Commonwealth's version of this, it's going to sweep up all these acts between two consenting adults, which will now be criminalized. And that's not
difficult to imagine a more private setting than the setting in this case. And it's difficult to imagine evidence of knowledge and consent.
It's difficult to imagine, Your Honor, but in the world we live in, moral attitudes, what people do change. And that's what Robertson is about. No, not Robertson. One of the other cases, Rahman is about. Unfortunately, the norms that I may have as a reasonable person, the norms that the cafe employee may have, goes to number 4, element number 4, the reasonable person standard. It doesn't go to number 5, which is that subject's standards. And that's what the legislature did in its plain meaning and what it did in its history. Because in the plain meaning, we can't look outside what those words were. And those words were and without that person's knowledge and consent. And the history of the legislature goes through that this 105B was created in response to what was going on in the world. You know, Wright, Commonwealth versus Wright, which is an appeals court case, mimicked Lepore, which was another case. And Wright said, look, this is what these people could have been charged under. They could have been charged under not a wiretap statute, but an accosting of another person. And the Commonwealth had that in their arsenal and they didn't use it. And that's evidenced by what they did at trial, bringing in the videotapes, which can't show it can't show these prior bad acts. It's got to show common scheme.
You've agreed with Justice McDonough that circumstantial evidence is sufficient in cases like these. In a case, again, where the defendant planted a flower pot with a hidden camera inside and took the video that we already discussed that is in the factual record, what type of circumstantial evidence would be sufficient to sustain a conviction in this case?
Well, in other cases where not only our courts, but courts from out of state, which are mentioned in the brief, one woman was seen, she was outside the room. The gentleman brought her in, the defendant brought her in, and then they could see her eyes were closed. There was a history where they had someone testify that, they had broken up, and he tried to use that videotape to basically blackmail her, and he did. And then they had sex again, and he videotaped her again.
Isn't that different than taking videos of strangers in a bathroom with a hidden camera?
Well, in that case, it was the justices, I believe, of New York found it was still a place of privacy. It was someone's bedroom. So whether it's a bathroom or a bedroom, I mean, it's still a place of privacy, which I don't think this court would deny. What you need, the videotapes that they have.
Let me refine the question. In a case like this, with these types of facts involving a setting like a bathroom with a hidden camera, as we've already discussed, what type of circumstantial evidence would be sufficient in your view?
Well, in Wasili, you have the admission of the defendant that's what he actually did because he was curious.
I think that's direct evidence. So what type of circumstantial evidence that you agreed would be sufficient, could be sufficient, would be sufficient in this particular case?
Well, that's the problem. I think this case is very fact specific, Your Honor. I haven't found any other cases like this where no bodily or facial expressions are used by the subjects themselves. There's none out there. But there has to be something for number 5. And it may be something that the legislature left out. But if they did that, then the accosting of another person could have been used as well. Because it's that 5th element, unfortunately, that doesn't bring it under this statute for the Commonwealth. That being said, Your Honor, if there's any other questions on that subject, I just want to move quickly to the videotapes that were introduced during trial. The Commonwealth wants you to believe that the standard of review should be lower. Our finding is that it should be prejudicial error. It is clear that during trial, the judge was well aware what the defendant was objecting to and what shouldn't be brought in. It was objected to at trial transcript 4 through 15. They had this big conversation. What the Commonwealth is trying to point to is a very small no objection by the defense counsel. What they were objecting to was the introduction of the SIM card was copied by the forensics, and then they sent the videotapes in. At trial volume number 3, 189, it's clear that the judge went through and said, look, I understand what you're arguing about. I have no problem with that. It's been covered. Let's go to a limiting instruction. So the standard is still the high one.
Can I interrupt you there? At volume 2, page 191, the ADA says, I don't think she was speaking to the SM card. What she said was the Commonwealth would move to introduce the CD into evidence as the next exhibit. And that's the CD containing all of the videos. And defense counsel responded, no objection. Could you address that, please?
Yes, that goes to the SIM card became a CD, so its copy was being introduced. But then on transcript volume.
The note, though, just so you have context, after the defense attorney said no objection, the court said it may be marked, and the transcript says Exhibit 8 so marked, DVD contains video from device.
That's just the containment. But what I'm saying, Your Honor, is that later on, trial transcript 389, Inspector Trubetsky from the police department testifies what's on the disc. And defense counsel stands up and says, I just wanted to renew my objection to the video, and I guess by extension to show it to the jury as grounds as before. And the justice says, all right, it was, I think we talked about this yesterday, the other day. I was inclined to say there's, and then they go on to what's the limiting instruction going to be. So it's preserved once again, as well as way back in volume 2, 4 to 15, the Commonwealth left out that the justice does say, look, but I certainly consider that anything to do with the playing of this video or any testimony of what contents is, the defendant has strenuously objected to and has not waived any objections. And I think you are protected, particularly with the latest pronouncement by the SJC. And what they're talking about was Commonwealth versus Grady, which had just been decided July beforehand. So that's the standard, Your Honor. That being said, I see I only have a minute left, so I will be quick. These videotapes should not have come in. It's clear that there was no authentication to these videotapes, where they were taken, if they were related in time, anything. They were shown just to prejudice the defendant. And that is clear because they were presented as one to the jury.
Are you talking about videos 1 through 7 or all of the videos?
Well, first of all, 1 through 7 were not authenticated. First of all, they weren't authenticated at all. They were just taking off the same card that was inside the defendant's video camera. No women were identified, which, that's really not the issue. There was no time to them. It was just that they were then, after that, presented as one to the jury. The whole shebang was given as in, see, they were actually introduced before those 4 were. They were presented with the inspector testified as all the women were presented this way. And that confuses the jury. The judge should have been the gatekeeper and said, look, this is overly prejudicial. There is no probative
Ms.
value.
Peterson, I see your time has expired. I'll ask you to sum up, please.
Thank you, Your Honor. With that, I would rest on my brief.
Thank you very much. Ms. Neyman, when you're ready, you may proceed.
May it please the court, my name is Nicole Lynn Neyman, and I'm an assistant district attorney with the Middlesex District Attorney's Office. First, there was ample circumstantial evidence from which the grand jury rationally could have inferred that each of the 4 victims, Jane Doe 1, 2, 3, and 4, had no knowledge that their private parts were being surreptitiously video recorded and that none of them had consented to it. If we turn to the record appendix at page 51, we can see the motion judge's decision on this issue, whereby he articulated the variety of evidence that was put forth before the grand jury to support these elements. Considering the location, which, as your honors noted, a person has a reasonable expectation of privacy, that when they go into a public restroom and they close the door, that there is an understanding that there is no video camera and that they have not consented to being recorded while they are using that bathroom in whatever way they see fit. And particularly because these women, these 4 Jane Does, were in fact using the bathroom and they were partially exposed and their private parts were being recorded, that is even further evidence that they had no knowledge and had not consented to being recorded in this instance. Moreover, when a former employee and thereby a patron of the restaurant entered that restroom and found the video recording device, her reaction, the fact that she was unaware that that video camera was there, and then when she found it, she was surprised and upset, that testimony could certainly be considered by the grand jury to reach out to the other victims, that they would have had the exact same reaction had they found that video camera. And the fact that they didn't was indicative of the fact that the defendant intended to secretly record these victims and in fact had secretly recorded these victims, whereby they could not have knowledge of what was going on and therefore could not consent. In addition, the grand jury also had the opportunity to review the CD with these videos on it. Now, my sister emphasizes the fact that because these victims' faces did not appear on the videos, that there would be no way by which circumstantial evidence could prove that they didn't have knowledge and didn't consent. But I would argue that a rational grand jury would find it very odd that a victim who had consented to being recorded or had knowledge that they were being recorded would not have their face on that recording. And in fact, if you review these videos, what you will find is that several of the victims, while the entirety of their face is not shown in those videos, a portion of their heads are shown. One of the victims, I believe the first one on the video, at the end of the video, her head actually tilts downwards and you can see that she is looking down. Surely not something someone would do if they knew they were being recorded. Additionally, that also occurs as to Jane Doe 4. There's a portion where she appears to be having her head down and not looking at any camera, thus indicating she was not aware that any camera was there and could not have consented to it. So there was surely sufficient information based on that alone. And then when the grand jury heard testimony about the defendant's conduct and what he did when this video camera was uncovered, that combined with all of the other evidence surely was sufficient for the grand jury to conclude, based on the state of the evidence, that the defendant had committed this crime and none of the victims had consented or had knowledge of what was going on.
Could you address the issue of authentication? And could you start with first videos 8 through 12, the videos ostensibly from the cafe?
Yes, Your Honor. As to the videos from the cafe, which were brought up in the motion in limine, as provided in the record appendix on page 58, there was more than sufficient information for the judge to conclude that the items in those videos were exactly what they were purported to be. And that is videos of women from the Kickstand Cafe between August and September of 2014.
What was the evidence from which one could infer, number one, that it was at the Kickstand Cafe, and number two, that it was at the relevant time frame?
Sure, Your Honor. There was a significant amount of evidence as to the distinct background of the Kickstand Cafe bathroom that was included in the videos, particularly the teal tiling, the lineup of the bar next to the toilet, and so forth. There was testimony by Emily Shea, the owner of the Kickstand Cafe, who reported that when she became the owner in November of 2013, she redid that bathroom as it was previously red and peeling back tile, and she changed it to teal. There was also testimony by Catherine Chisholm, who was a former employee, who also described the teal black splash that was very distinct. And she, along with Emily Shea, identified a still frame photo taken from those videos as being at the Kickstand Cafe. Moreover, the detective also testified that he had observed the scenario and had seen the bathroom and there was a teal backsplash. And he testified that the images were clearly taken at the Kickstand Cafe.
So how about the more difficult question? What about videos 1 through 7? How are they authenticated?
Your Honor, those items were authenticated because they were what they were purported to be. And they were authenticated via the expert testimony of Carl Schiller. If you look to trial transcript 2, starting at, I believe, page 190 to 193, Carl Schiller walked through the steps that he took to explain the videos that were taken from the DVR SIM card that were placed onto a CD and what was on that CD. He reported the steps he did to download those videos, how none of them were changed, and they were exactly as they were seen on the DVR SIM card. There was also testimony about the chain of custody, whereby how Carl Schiller received this DVR SIM card from the officers who had obtained it on the defendant's person inside his duffel bag on September 13th, 2014. And the issues of whether in fact that is an accurate description or an accurate representation of particular women in particular bathrooms and when that occurred and where it occurred, those issues go to the weight of admissibility and not to admissibility itself. And so the jury was allowed to assess what in fact that image was, but there was no question that the images on videos 1 through 7 were what they were purported to be, which was the exact videos on the SIM card of the DVR found in the defendant's duffel bag.
But aren't they purported to be videos that were taken by the defendant on dates that weren't too remote in time from the actual incident for which he was charged?
So I would answer that question, Your Honor, in 2 parts, but yes. The first part is that the defendant did not preserve this issue. And so
please assume it's preserved for purposes of this question, number 1. And number 2, I'd just like you to get to what evidence there was of temporal and schematic nexus under the subsequent prior bad acts analysis.
Yes, Your Honor. So the evidence that the defendant took this video was clear by the depiction in video 3, which was an image that was purported to be the defendant setting up this video recording device in a different location. And there was testimony that the individual who was setting up that device appeared to have the same stature as the defendant. And there was also just the explicit testimony itself that it was found on the same SIM card that had the other videos that was in the defendant's possession with the recording device in the DVR. So certainly sufficient to connect it to the defendant himself. As to the timing, Your Honor, of these videos, it is significant that the defendant made certain admissions about when he obtained this DVR and the recording device in the flower pot. There was testimony by the defendant that was played in the interview that was introduced, Your Honors, that you have available to you, whereby the defendant explains when he obtained these items from the cemetery. And while there is some contradiction,
It appears you're frozen on my screen.
conclude that these video recordings has a sufficient nexus by which the
frozen. So I'm going to ask our clerk. We can resolve the glitch.
Am I back, Your Honor?
You're back now, but hold on for just a minute. Maybe we could add a minute of time.
We can restart the timer. Where are we at? I've got a 7.5 minute one. Would that work?
Yes.
Counsel, I think where you glitched, you were discussing the evidence of the timing. So if you
Yes,
could
sir.
start there again, please.
And so the defendant testified in the interview with the officers after he was arrested that he had obtained this DVR and the flower pot from a cemetery either 2 weeks or perhaps several months before the incident. But that admission alone is certainly sufficient to find that in the past several months, these video recordings had occurred and the defendant had possession of them. And so that is certainly a sufficient nexus by which you could relate these acts as to the charged acts that happened sometime later. And the important part is that these acts were not so prejudicial in the sense that there was a clear limiting instruction when they were introduced. And in fact, before the videos were played, the trial court went through not only that all of the videos would be played, that they were uncharged conduct, that they should not be considered for propensity purposes. And there was quite a colloquy on that fact. And then that instruction was repeated, of course, during jury instructions. So there was no risk, whether the error was preserved or not, that there was an error in the admission of these prior bad acts. It is also important, Your Honors, to note that these videos were short clips. If you look at all of the clips together, they're approximately less than 3.5 minutes long. And so any viewing of these evidences or of these uncharged acts were not so significant that the jury would not be able to consider the judge's limiting instruction in light of all of the evidence before them and make a determination of guilt based on the charged conduct, not the uncharged conduct, which I will note was significant for the Commonwealth's case in that the defendant relied on the fact and had testimony that he was incapable of using these devices because he was not technologically savvy. And so these uncharged acts were important not only to demonstrate a lack of mistake or accident, but the intent, which were elements that, while not being challenged on appeal, were elements that the Commonwealth needed to demonstrate beyond a reasonable doubt. And so these uncharged acts were significant in showing that. But I would also note that there was a variety of evidence that was more than sufficient to meet the Commonwealth's burden, regardless of whether these 7 videos came in. And so even finding that they should not have come in, it would not create a substantial miscarriage of justice such that the same verdict would not be reached. I will note, Your Honor, that as to the objection point, I would just like to clarify that when the defendant did not object to the entrance of Exhibit 8, not only did defendant stand up and say no objection, but then the defendant entered and published to the jury Exhibit 9. Now, Exhibit 9 was a still frame of what is video 3 on Exhibit 8. And that video is the man purporting to set up the camera. But that is the uncharged conduct that the defendant is contesting should not have been allowed in. And so at that point, when the defendant introduced that evidence and in fact said no objection and was using that evidence to their defense, there can be no way that they then later can just say, well, now I'm objecting, although certain portions of that evidence served my defense, the rest should not come in. And so when the defendant did stand up the next day and said that I preserved my objections, the day before those objections had been waived, and they had been waived as to authenticity and as to the prior uncharged acts, and that is significant. If there are no other questions, Your Honor, I would rest on my argument and my brief at this time.
Seeing none, Ms. Neyman, thank you very much. Counsel, thank you both for your argument. It's been very helpful.
Thank you, Your Honor.
The case is.
We are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to today's session of the Massachusetts Appeals Court. Today we will be conducting arguments via Zoom. They will also be broadcast live on YouTube. My name is Jeffrey Kinder. I'm joined today by Justice Eric Neyman and Justice McDonough to hear argument in the case of OMAR ZOUHAR versus Belmont Hill Corporation, case number 19P1502. Our session this morning will be conducted in the same way it would be conducted if in the courtroom. That is, each side will be given 15 minutes of argument. There will be no rebuttal. We may interrupt with questions from time to time to help clarify your arguments or clarify aspects of the record. Please keep in mind that we have read your briefs and the relevant portions of the record very carefully, so your time is best served by getting right to the heart of your argument. With that, let me turn to counsel for the appellant, Ms. Khan. I'm sorry, I have that backwards. Let me turn to Ms. Fierro, counsel for the appellant.
Thank you, Your Honor, and good morning. Meredith Fierro here on behalf of Paramount Insurance Company. This case is about the standard that judges should use when deciding whether to approve the allocation of a third-party settlement under the Workers' Comp Act. In this case, the Superior Court applied the wrong standard because it did not evaluate whether the allocation between lost wages and medical expenses and pain and suffering damages was fair.
That's a great segue to my first question,
Yes.
which is, you both seem to agree that the standard of review is clear error. But aren't there cases that suggest that when a judge does not apply the correct standard required by a statute, that the standard of review is otherwise? I think in some cases it might be de novo. In other words, I think there's an argument that there's a more favorable standard than what I would call the high bar of clear error. Could you address that?
Sure, that is true. Generally, the legal standard is reviewed de novo as opposed to factual determinations, which is either clear error or abuse of discretion. Here, we are both relying on, I think, the standard of review that was cited in this court's decision in Halton, in which they noted that it was clear error. But of course, I agree with you, Your Honor, that because this is a really determination of the legal standard, there's no factual issues in dispute. We do not dispute that there was evidence that the plaintiff suffered $92,000 worth in damages. Our sole argument is that the standard of review was not correct, that there is an argument that de novo would also apply. Thank you. So again, the Superior Court applied the wrong standard because it confined its review to whether the dollar amount allocated to pain and suffering damages was supported by the evidence. In doing so, the court approved a settlement agreement that allocated 92% of the recovery to pain and suffering damages and only 8% to lost wages and medical expenses. This was erroneous for two reasons. First, the Superior Court misapplied the SJC's decision in DiCarlo versus Suffolk Construction. Second, the standard used by the court is inconsistent with this court's decision in Halton versus Francis Harvey and Sons, as well as the SJC's decision in Lane versus Plymouth Restaurant Group. So I'll start with DiCarlo. So the Superior Court seemed to interpret DiCarlo as an instruction that its exclusive focus in reviewing a third-party settlement is to determine whether there was evidence to support the amount awarded to pain and suffering damages, solely to ensure that the employee does not receive double recovery, and that that's the only concern before the court. But that's not what DiCarlo says. The SJC did hold in DiCarlo that pain and suffering damages are not subject to the workers' comp lien because the workers' comp insurer does not pay for pain and suffering. In justifying that outcome, the SJC stated that allowing the employee to receive both workers' compensation benefits and pain and suffering damages would not constitute a prescribed double recovery. But the SJC also noted in its decision that preventing double recovery is not the only purpose of Section 15, and Section 15 has the additional aim of reimbursing the workers' comp carrier. So the SJC emphasized at the end of its decision that its holding in DiCarlo would not deprive a workers' comp carrier of its right to be reimbursed, because all settlements have to be approved by either the Department of Industrial Accidents or a judge. And importantly, the court in DiCarlo concluded its decision with the following warning, and I quote, "A settlement amount allocated entirely or in large part to pain and suffering will be eyed by the court with a healthy dose of skepticism," close quote.
Counsel, let me jump in there.
Yes.
By the way, the brief was excellent, but you indicate that the appeals court decision in Curry and DiCarlo affected a sea change, and I think that's accurate. And under the old rule, you'd get first dollar, your lien would go to the first dollar, and you're proposing a third, which I'm not surprised, because that was the old pretty much rule of thumb, a third, because you had first dollar coverage, and if it's a small recovery, there's no way to settle the case if the insurer gets everything. But that's the prelude to my question. You say the plaintiff shouldn't get first priority. You use that a couple of times, but don't we first have to determine, if you're the judge, what's the amount where you have no lien? As you point out, you don't have a lien on something you don't pay. So it seems to me the judge let's first find out what you do not have a lien on. And is that a fair and reasonable amount? And given that we have someone totally, I won't go into some of the graphic detail, but someone who has just been totally devastated, don't we first have to say, what's the amount that's fair that goes to that person for pain and suffering that you do not have a lien on? And then on what's left over after that, you do have a lien on. Why is that inconsistent with DiCarlo? It seems to me that that's first, let's find out what you do not have a lien on, and then we'll deal with the rest of it. Why is that wrong?
So I agree with Your Honor that when you're determining the fairness of the allocation, you can start with the pain and suffering damages and evaluating how much you think that plaintiff suffered in pain and suffering. The problem here is that the Superior Court ended its analysis with that, and it did not also look to how much the workers' comp carrier had paid in benefits and compare those two numbers to determine whether the allocation was fair. So in ending it by looking to simply whether the dollar amount awarded to pain and suffering was supported by the evidence and concluding its analysis there and not comparing it with the evidence of lost wages and medical expenses.
Why do you have to compare a number that you do not have a lien on? You don't have a lien on the suffering. Why is there any comparison between an amount you don't have a lien on and the amount left over?
To determine the fair allocation of the settlement. So whether those percentages that are allocated to both numbers are fair. So it's really a question. It's yes, you initially start with determining the amount, the dollar amount to both. And then you look to whether the likely trial recovery and whether those percentages in the settlement are fair.
So let's take a ridiculous example. Let's say it was just a whiplash case and the judge made the same allocation here to that hypothetical to here. Then you would say, well, that's not fair because the injuries aren't even close to what has been allocated to pain and suffering. But how can you argue any amount? You could be in the tens of the millions with the suffering here, couldn't you?
Hypothetically, but that's not what the judge found. So I think that...
Let me try it this way. Why is a third... You didn't ask for a remand here, I noticed. You just
I think we did ask for a remand. We reversed and remand.
All right, I missed that.
I think necessarily it would have to go... If I didn't make that clear, I apologize. But necessarily it would have to go back to the judge because The parties would
All
have
right.
to propose a new settlement to go back for.
So why would a third be fair and reasonable, where you get, the insurance company gets just as much for someone whose life has been absolutely obliterated by these injuries? Why would that be fair?
We simply proposed an alternative allocation. It's difficult to determine how much pain and suffering damages there are, right? This is one of the problems that was created by the Curry and DiCarlo decision. Is initially, it used to be that you didn't have to break up those damages and simply the insurer got first priority. Now I acknowledge it's difficult to figure out how much those damages would come to. Here, I don't think that there was evidence that there was millions and millions and millions of dollars in pain and suffering damages. Certainly the judge could have found that there was a high amount in pain and suffering damages, but he simply said that there was $92,000 worth of pain and suffering damages. And implicit in his suggestion that the likely trial recovery would benefit the comp carrier's position suggests that if this went to trial, we would not receive only 8% of the 8% of the recovery, and that we would probably receive more than that. Does that answer your question? I'm not sure I did.
Sure.
Okay, thank you. So I think this judge, in a way, he set this case up well for an appeal in that he set out that there were two ways in which that you could view the allocation and decide whether it was fair. And so he first said, of course, that you could view it through the lens of likely trial recovery. And that if that's the way that he viewed it, then our position was strong because of the amount that the comp carrier paid in workers' compensation.
But does the statute say anything that you have to look at it that way as to what the likely trial recovery would be? I didn't see anything like that in the statute.
It doesn't say it in the statute, but the difficulty is the statute does say that the sum recovered should be the benefit of the insurer. But of course, now that's been interpreted where the injury is limited to simply the injury for which the workers' comp insurer pays benefits. So really where I'm getting the likely trial recovery is this court's decision in Holton versus Francis Harvey and Sons, and the SJC's decision in Lane versus Plymouth Restaurant Group. So I'll start with Holton. So Holton involved a third-party settlement, which initially allocated 90% of the recovery to the injured employee's wife's loss of consortium claim and only 10% to the comp carrier. And the Superior Court judge said that that allocation was unfair, rejected it because it was unfair to the workers' comp carrier. So the parties renegotiated and came back with a new proposed allocation of 21% to the injured employee and 79% to his wife's loss of consortium claim. And the appeals court held that this allocation was fair under the circumstances because of the relative strength of the claim. So it was comparing the claims. So the appeals court said that because the injured employee, there was evidence that he was of his comparative negligence, that would substantially weaken his claim, but it wouldn't affect the wife's loss of consortium claim. So since the loss of consortium was the stronger claim, it was fair to allocate 79% to that claim. So what the appeals court essentially did in that case was they looked to what the likely trial recovery would be in determining the fairness of the allocation. Even though it's a different context, I think that the underlying principles still apply here. And the SJC did the same thing in Lane versus Plymouth Restaurant Group. Again, slightly different context. This involved a wrongful death claim and a claim for intentional infliction of emotional distress that was filed by the deceased employee's husband and 4 sons. The way that the settlement was structured, only 10% would have been allocated to the workers' comp lien, which that represented the husband's wrongful death claim. The Superior Court judge approved it, and the SJC reversed because the Superior Court did not allow the workers' comp carrier to present evidence that the allocation was unfair. But in remanding the case back to the Superior Court, the SJC instructed the judge that it should look to the comparative worth of the claims when determining the fairness of the allocation. So again, the likely trial recovery. So here we contend that the judge erred because he did not consider the likely trial recovery. He explicitly said that's not how he was viewing the case in his decision. And instead, he solely looked to whether the dollar amount allocated to pain and suffering was supported by the evidence. So that deprived the insurer of, he didn't look to basically the insurer's reimbursement rights. He didn't consider that at all in his decision, even though, as the SJC acknowledged in DiCarlo, one of the aims of Section 15 is to reimburse the insurer. So we are arguing for a balanced approach where the judge,
Counsel,
yes,
forgive me. Can you remind me the cases you're stressing, Lane and is it Hova? Forgive
Holton,
me. Holden, forgive me. Are those cases before DiCarlo and before Curry?
yes.
Thank you.
Yeah.
Counsel, you noted in your brief that in DiCarlo, the SJC did not provide what you called concrete guideposts in terms of telling judges how to allocate funds toward pain and suffering.
Yes.
Are you asking us to impose concrete guideposts? Because if not, then it seems that the SJC is telling you this is on a case-by-case basis, and they're imposing a clear error standard of review because they're saying the judge not only has discretion, but these are such fact-specific matters that it'd be pretty difficult for an appellate court to interfere with these decisions.
So I think it's on a case, of course it's on a case-by-case basis, but the stand when you're deciding whether the allocation is fair. As far as the standard that the judge applies, I don't see why one trial judge should apply one standard and one trial judge should apply a different standard. Yes, it is difficult to determine how much there is in pain and suffering or how much an allocation should be fair, because unlike in Holton, where they noted that a loss of consortium claim, maybe 20 or 30% was around the general allocation there, there's no exact suggestion of numbers. In DiCarlo, I think there was 30%, one of the plaintiffs was 30% pain and suffering, and the other plaintiff, Benjamin Martin, was 35% pain and suffering. But the SJC didn't rule on that allocation. So it's difficult to determine, but what I'm asking this court to do is to state in its decision that the standard is that the judge should look to the likely trial recovery. How the judge does that, yes, there's some discretion, but the judge can't confine its review simply to whether it's fair to the employee, to the employee's pain and suffering. The judge also has to consider the workers' comp carrier's reimbursement rights and how much the comp carrier paid in benefits to the employee when approving the settlement is fair.
That's helpful. Thank you.
Well, if there's no further questions, I'll rest on my brief.
It appears there are no further questions. Thank you, Ms. Fierro.
Thank you.
Ms. Khan, when you're ready, you may proceed.
Good morning. My name is Sarah Khan on behalf of Plaintiff Appellee Omar ZOUHAR. The standard here is whether or not the Superior Court judge's decision was clearly erroneous. He did apply the law, and as the judge that held an exhaustive hearing on the facts applicable to the allocation here is in the position best to make a decision akin to a bench trial. The facts that were left out of the appellant's brief were that there was a hearing here where Mr. ZOUHAR did offer oral testimony. There were sworn statements by doctors. He was
Counsel, can I jump in? Maybe I didn't find it. I didn't find any testimony in the transcript. I saw just I'm not suggesting you need testimony, but I just wondering if I missed something. I just saw a transcript of the hearing where argument of counsel. I didn't see any sworn testimony. Is that correct?
That's not correct. I'm not sure why the testimony of Mr. ZOUHAR was not included. And at that hearing, Paramount Insurance Company's counsel had the opportunity to further question, cross-examine Mr. ZOUHAR, or call them up for their own exhaustive questioning, and they didn't do that.
Were you at the hearing, counsel?
Yes.
Okay, thank you.
Yes. So in addition to that, they didn't present any counter evidence that the pain and suffering allocation in this case was not supported by the facts. So they simply are equating that the standard applied was unfair and inaccurate and should be overruled because they're unhappy with the result because it doesn't follow the standard rule of thumb of 1/3, 1/3, 1/3, which is what they were proposing here.
Ms. Khan, what if
Yes.
the judge had found that the pain and suffering damages were $100,000, and so he would have allocated the entire settlement amount in that way? Could he have done that?
Your Honor, it would depend on the reasoning. I think the reasoning for the Superior Court judges highlighted by the brief and comments at the hearing was that the allocation was not based on the fact that his pain and suffering was 92,000 or 100,000, but that it greatly outweighed the medical bills and the wage loss, and that Curry as well as DiCarlo established that the whole point of the Section 15 recovery is to only recover for things that the comp insurer pays out for, which is wage loss and medical bills. In this case, they don't pay out for pain and suffering, so they can't recover. And in a case, without getting too graphic, where a 41-year-old is going to be suffering for the rest of their life with things like incontinence, inability to drive, having to wear a diaper, that's supported by sworn statements from their treaters with no counter from Paramount Insurance Company, the pain and suffering allocation here is justified. And the Superior Court judge rightly looked at the totality of circumstances in this particular case. This is not just a case where someone has some bruising or a headache. This allocation is incredibly significant because the pain and suffering in this case is incredibly significant and will continue for a long, long period of time.
How do we square on this record? How do we square the fact that the insurer paid out, as I recall, over $500,000 with an $8,000 recovery?
Your Honor, I think in a settlement such as this, where given the medical damages being so large, in addition to the wage loss and the pain and suffering, where the settlement's only $100,000, nobody is getting the result that they should. And part of the reason for the settlement was because liability wasn't clear in this case. And that's why this was in the best interest of the client to settle at this point. By no means does this $100,000 settlement allocated in whatever way, even if it was the full $100,000, compensate plaintiff for their losses. But the settlement was reached with the understanding that the result could be zero. So I think that it doesn't stack the deck against the insurer to have the allocation in this way. It's based on the totality of the facts and circumstances in this case, and the facts overwhelmingly support that the allocation for the pain and suffering is greater, because the pain and suffering in this case is much greater than the medical bills or the wage loss could ever amount to. And it's not a ratio or a bright line formula. It's not a mathematical application. In this case, yes, Paramount Insurance Company did get an allocation of 8%, and if you just look at it based on math and what the previous rule of thumb was before this new case law, then it seems as if it's not fair. But upon an examination and thorough review of the facts in this case, which is exactly what happened at the Superior Court level, with no counter evidence provided by Paramount Insurance Company, the Superior Court judge came to the right decision, applying the law, not based on recovery, because in reality, there may have been no recovery. So that's not a way that would give it a fair result to anyone on that basis, but rather whether or not the allocation is fair, and if it's not just arbitrarily designed to remove recovery from the workers' comp insurer, which did pay out a significant amount in this case. As written in the brief, I would argue that Curry is not a loophole, and it simply acknowledges that the workers' comp insurer cannot recover for things they never paid out for in the first place. They don't pay out for the headaches that Mr. ZOUHAR would suffer, or having to deal with the humiliation of wearing a diaper or not being able to marry. All of those things were presented at the hearing, and that's why pain and suffering in this case would be great. And if it did go to trial and plaintiff did have a recovery where they overcame the insurmountable liability issues in this case, the pain and suffering would greatly outweigh the $500,000 in wage loss and medical bills in this case that is held by the lien from the Paramount insurer. And they even acknowledge that there's no double recovery in this case on page 22 of their brief. They acknowledge that they are not countering that the pain and suffering experienced by Mr. ZOUHAR is incredibly significant, and they don't even counter that it's permanent. So simply appealing this decision on the basis that the result is unfair and it's not standard it doesn't mean that the law was not applied correctly by the Superior Court judge. And I'd argue that it was, and it was thoroughly examined with the hefty dose of skepticism as required by DiCarlo, and the facts were beyond what are normally presented to support the level of pain and suffering. Having sworn statements by treaters who are not even paid experts supporting this, with no counter from the other side when they had the opportunity to do so, were weighed by the Superior Court judge, and ultimately is the reason why this allocation was upheld. And we're requesting that there is no bright line rule applied, and because all of these cases are different and they require that a hearing be held approving allocations that are not agreed upon, that the court apply the clear error standard as the law was applied correctly. A thorough hearing was conducted. The parties had opportunity to put on evidence beyond oral testimony, including contrasting expert reports. And the court didn't fail to factor in that the purpose of one of the purposes of Section 15 is to reimburse the insurer. They simply looked at all of the purposes of settlement, allocation, and approval, and in this case, allocated more greatly to pain and suffering based on the facts and circumstances. If your honors have no further questions, I would rest on my oral argument and brief.
One brief question, and that is
Yes.
this. Just assume for the sake of argument that the judge did not apply the correct statutory factors or misapplied the standard. Assume that hypothetically. Is the standard of review still clear error?
If the judge did not apply the applicable law, I would say that it wouldn't be, arguably wouldn't be a clear error standard, but given the application of DiCarlo, Curry, and the thorough analysis as required and established by that case, as well as considering all of the parties to be reimbursed in their standing in this case, I would say that the standard would be clear error, Your Honor.
All right, seeing no other questions, the case is submitted. I want to thank you both for your argument. It's been very helpful.
Thank you for your time.
Welcome to this morning's session of the Massachusetts Appeals Court, which is being conducted via Zoom and also will be broadcast live on YouTube. Joining me today is Justice Eric Neyman and Justice Edward McDonough. My name is Jeffrey Kinder. We will be the panel on this case, which is 19P 1402, Robert Paine versus CHELLISE Sexton. Counsel, bear in mind that we will operate today's Zoom hearing just as we would if we were in the courtroom. By that, I mean each side will have 15 minutes. There will be no rebuttal. We have carefully reviewed your briefs. I notice we have lost Justice McDonough. Hopefully he can still hear us and we'll be back shortly. There he is. We have read your briefs. We've read the record carefully. So my suggestion would be that you get to the argument right away on your strongest points of law. With that, I think we're ready to proceed. So let me turn to Mr. Schultz on behalf of CHELLISE Sexton for his argument. Mr. Schultz.
If it pleases the court, Albert Schultz representing CHELLISE Sexton, defendant appellant. This case involves the exclusive element of adverse possession, not the adverse or hostile element. Also, I'd like to emphasize that this is not the campground case. The campground case did not involve locus, which was used by Irene Paine, a third party. Lot 1 was never claimed by the campground. And I refer to the affidavit of Robert S. Paine, the petitioner's father, at Appendix 374 to 377. And there was no evidence that they ever claimed the campground. This case was filed.
Mr. Schultz, can I stop you on that point? Judge Sands went to great lengths to explain the reason for bifurcating the so-called campground case, that his decision with respect to adverse possession might well moot the issues of title, which he found or described as more complicated. It's not clear to me, even though you have described this as not the campground case, and I understand that, it's not clear to me how the evidence of adverse possession would be any different if we were to remand the case for a trial with respect to the locus? Would it be?
Certainly, because locus is made up of two parcels. Lot 57, which is the northern portion. Robert and Cynthia had a color of title deed to that parcel. Lot 58 is the southern portion. Irene had a color of title deed to that portion of locus. So you have two colors of title. The court ruled in the land court case that the campground obtained title to lot 78.1. That did not include locus. The fact that Robert and Cynthia had a color of title deed only, that didn't automatically entitle them to a finding of adverse possession for lot 58, that portion of locus that's shown as lot 58. They still had to prove their elements of adverse possession, as in any adverse possession under color of title. So no court has ruled that the campground ever obtained title. And it was clear from the affidavits and the deeds on record that the campground never claimed a title. And there is no evidence also that that Irene ever used any portion of lot 78. So summary judgment is only appropriate where there are no material facts, and that the petitioner is entitled to a judgment by operation of law. In his discussion, the court made 19 19 numbered facts, which he said were the undisputed material facts in the record. At pages 16 to 18 of the decision, he then goes on to explain, and I'll read a little bit of it. He claims that undisputed evidence that Irene and the parents collaboratively occupied the properties in question and came to an understanding that Irene would use the front part and the parents would use the back part for the campsites. And that continued for 20 years. And it was obvious that Irene was permitted to occupy the northern portion of the locus and her parents on her parents' behalf, and that the parents were entitled to use, or by agreement, occupied the southerly portion on behalf of Irene. Without an agreement or permission, there can't be any exclusive use of locus.
Let me ask you about that, Mr. Schultz. As a general proposition in the law, agreements can be proved in many ways. One is by a written document. Another is by circumstantial evidence. Why couldn't the judge consider the use of the property by these family members as circumstantial evidence that it was permissive?
Because we have the case of Totman versus Malloy that says there's no presumption of permissive use between close family members.
Well, I grant you that there's no presumption, but the judge was entitled to consider it as circumstantial evidence, was he not?
Well, no, because he went beyond the summary judgment record. There's absolutely, the record is absolutely devoid of any evidence of an agreement. It wasn't in the summary judgment record. So he had to go outside the record to find that.
Well, let's say, I happen to be living in a structure right now that has 2 apartments, and my daughter and her husband are living in the other apartment. If there was evidence of that living arrangement, isn't that circumstantial evidence of permissive use among family members?
It might be, but I don't think that that's any evidence in this case. Well, it wasn't in the record.
All right.
The summary judgment record was limited by those 19 material facts. And I don't think there was any evidence, whether it was direct or inferential.
Let me ask a flip side question. Was there any evidence that would suggest or imply that the use was not permissive?
Again, there's nothing in the record that would suggest that. But you'd have to presume that. You'd have to presume that it was, well, I would say that the affidavit of Robert Paine suggests that Robert S. Paine, the parent, that was recorded in the Registry of Deeds. He said in 2000, and I think it was 6, that his son was trying to claim a portion of the northerly portion for the campground. That's what it suggests. But other than that, there's no evidence of any agreement or permission in the summary judgment record. Now, my second point is that Irene's or Paine's now adverse possession to locus is limited to that portion of Lot 58 that is located within Parcel 6 on the lay study sketch. It's undisputed that Lot 1 is the southerly portion and of Parcel 6 and the westerly portion of Lot 16 on the lay study sketch. Irene has color of title to 58, the southern. She has no color of title to Lot 57. Judge Sands ignored the record title. And that's important because color of title doctrine applies only to a parcel described in the deed, which an entry has been made and to which the claimant has no record title. Irene has no record title to either 6 or 16. But she entered only, the only evidence we have is that she entered upon that portion of Lot 16 that is within 58 and moved a house onto it. Her entry upon Parcel 6 doesn't give any constructive notice over Parcel 16 or any other parcel. And I'm citing the Dow versus Dow case and Tutoro versus Cheney. That was a land court decision. This is all about lack of notice to the owner of the parcel that has been physically occupied by the claimant. Here, Irene's activities on Parcel 16 or Parcel 6 could not have provided constructive notice because she didn't do anything on Parcel 16. So how would the predecessors entitled to Sexton have any idea if she didn't enter it upon that parcel that she would have adverse possession or claiming that parcel? So if someone enters on your property and you have no notice of his claim, you don't have any constructive notice. And finally, the appellees argue that Sexton is a stranger to the title. This case was started in 1999. The Land Court Examiner's report was not filed until 7 years later in 2006. The citation issued, return day, well, it was 2 more years before the citation issued. Return day was June 9th of 2008. In 2010, Sexton, who had no prior notice, none of her predecessors in title were named in the citation. In fact, the land court examiner cited the wrong deed for locus in his report. Judge Trombley allowed my client to file a late answer. So a late answer dates back to would date back to the time it was due. The court found that
did Judge Trombley address specifically the standing argument that Ms. Toronto Flores now raises?
He did, I believe. Yes, he did. So,
and what's our standard of review of Judge Trombley's decision to allow that late filing of an objection to registration?
I would think it would be abuse of discretion. So the court found that Sexton holds a record title interest in parcel 6. My client was never defaulted. There's a process under 185 to default people and to enter under, I think, Section 43. That process was never requested or acted upon. So I believe that Payne's argument that my client is a stranger to the title is without merit.
Thank you.
Do you have any questions?
Let me see if my colleagues have further questions. Seeing none. All right, thank you very much, Mr. Schultz. Your argument's been helpful. Ms. Toronto Flores, when you're ready, you may proceed.
Good afternoon, and may it please the court. Sarah Toronto Flores on behalf of the petitioner, Mr. Robert Payne. As Mr. Schultz has just indicated, Mr. Payne is seeking title in this case to lot 1 on the petitioner's plan, which is at page 35 of your appendix. And as you've all read and he previously mentioned, Mr. Payne succeeded previously in establishing title, a judgment of title sufficient for registration from the land court on lot 2 on that plan, which is a 36+ acre parcel of land that abuts lot 1. That case, as this court will have read, was tried in front of Judge Sands after a 4-day trial with 11 witnesses, hundreds of pages of exhibits, a site visit, and further summary judgment briefing on color of title. Ms. Sexton participated fully, had full and fair opportunity to participate in those proceedings. And the decision came down that by virtue of Mr. Payne's parents' use and occupation of lot 2 and their operation of lot 2 as a campground, openly, notoriously, continuously, exclusively, and adversely since at least the 1950s, he had sufficiently established title through adverse possession and adverse possession under color of title to the bulk of lot 2 shown on that petitioner's plan.
Counsel, I want to just cut to the chase. Could you address Attorney Schultz's contention that the summary judgment record is devoid of evidence that the Paynes, I'm quoting now, in concert with their parents collaboratively or collectively occupied the properties in question? I gather you disagree with that proposition. And if you do, where is the evidence in the record?
Well, so first of all, the evidence in the record regarding their permission is in the affidavit of Robert Payne Sr. that is included in Ms. Sexton's appendix to the summary judgment appendix. But more importantly, I think, and Judge Vey previously determined this when he denied Ms. Sexton's motion to amend the decision, that finding of permissive use or a collaboration, as the judge put it, is immaterial to the essential decision of color of title under adverse possession in this case, because permission between adverse possessors doesn't defeat an adverse possession claim. Only permission by the true owner would defeat that claim. And in this instance, the evidence as set forth in Mr. Payne Sr.'s affidavit and as found by the judge is permission between Irene, the sister, to her parents to use the rear portion of her lot 58, and her parents' permission to her to use the forward portion of their lot 57. They are both adverse possessors using that land under their color of title deeds, and as such, the case law is clear that that is not enough to defeat their claims, both on the adverse prong and the exclusivity prong. And that is set forth and extensively explored in the case of Lawrence versus the town of Concord, cited in our brief, 439 Massachusetts 416. That's a 2003 decision where the adverse possessor didn't occupy the land himself, but leased it, and his tenants occupied it.
Was the PAINE affidavit that you're referring to disputed in any way? Or was there a counter affidavit or response to it? And also, did the judge make any references to that affidavit in his findings as to this issue?
I don't know off the top of my head if he cited to the affidavit, but the affidavit is included in Ms. Sexton's appendix. So therefore, it's not disputed. She proffered it as evidence. And it does speak to them agreeing to the use of the property in the property line. Again, I can't stress enough, though, that this permissive use, as Judge Vey found, is not material to the finding, because permission has to be from the true owner and not from people who are adversely possessing. Judge Vey's decision is at page 481 of your appendix. I'm sorry, it starts on page 475. His discussion of this particular issue is at 481 to 482. He speaks to how these findings are made because they're in response to arguments raised by Ms. Sexton, and that they provide context but are not material to the finding of color of title here. What I think I'd like to review for the court is Ms. Sexton's response to our statement of finding of undisputed facts. Her response is found at page 344 of your appendix. This is very, very important because you will see that she admits to every single fact save one. And in particular, she admits to the fact that Payne's parents received a deed in 1971 to a lot described as lot 57 on the 1964 assessor's maps. You know, those assessor's maps that are set forth page 200 and 290 of your appendix are very, very helpful in illustrating that all of both the campground lot 2 and lot 1 are shown as a series of woodlots. These long, thin woodlots extend from Old Kings Highway on the west to the National Seashore on the east. And lot 2 is, as Mr. Schultz just said, comprised of lot 57 and lot 58. Lot 57, there was a deed for lot 57 to Payne's parents in 1971. This is conceded by Ms. Sexton in her response to Payne's statement of facts, and the deed itself is included in the record appendix. She further admits that in 1978, Payne's sister Irene obtained a deed for lot 58 on the 1964 maps. Again, the deed is in the record. The statement of facts further admit that there has been a single family dwelling on lot 1 since 1978. They further concede that in 1998, so the deeds, the color of title deeds that they were both operating under 1971 and 1978, they used their respective lots up until 1998 when an A&R plan was recorded. That's in the record. And that was a combination of lot 58 and 57 and the carving out of lot 1, which is locus in this proceeding. Those facts are all conceded by Ms. Sexton in her response to our statement of facts. Ms. Sexton then further concedes to the previously adjudicated findings of this land court, as upheld by this court, in the campground case. And in particular, the land court's previous finding that Payne's parents acquired title to the entirety of lot 78.1 by adverse possession. Now, Additional findings are conceded by Ms. Sexton in her response that the middle portion of lots 57 and 58 are shown as lot 78.1 in the later Wealthy Assessor's Atlas from 2010. So that center portion, lot 78.1, the court previously determined that Payne's parents had acquired title by adverse possession to the entirety of it. In its color of title decision following trial, the land court further found that by virtue of Payne's parents' use of that center portion, Payne had established title to the easterly portion of lots 57 and 58 as they abutted the national seashore under the color of title theory, which allows you to extend the use even beyond the part that you're actually physically occupying to the four corners of the deed, because it found that the deeds for lot 57 and 58 using the same 1971 and 1978 deeds that we're using in this case contain sufficient descriptions to extend that title all the way out under the power lines to the edge of the national seashore. In this case, we're seeking to apply those same facts and reasoning to the westerly part of lots 57 and 58, where lot 1 has been carved out along Old Kings Highway. Now, importantly, we have deeds, and they're in the appendix, the summary judgment supplemental appendix filed by us, the petitioners. We get deeds, Mr. Payne derives his title from the deeds between Irene and her parents down to him. So not only do we have Payne's parents' use of lot 57, the rear portion as part of the campground from the moment they got their deed in 1971 and even earlier through to the campground litigation. But we also have Irene's use, and this is undisputed, from 1978 when she got her color of title deed to lot 58 when she put a house on it. That's also undisputed in this case. And again, these facts remain all the way through to the present litigation. So we have both facts to establish adverse possession, and we have color of title deeds that extend all the way from Old Kings Highway on the west to the national seashore on the east. This combination of facts, undisputed facts and or previously adjudicated facts, more than amply supports the court's finding here that color of title, that Mr. Payne had established title by adverse possession under color of title to the westerly portion, which is shown as lot 1 on the petitioner's deeds. You'll notice in our brief that we speak extensively in support of Judge Sand's finding that Ms. Sexton must be precluded from challenging these earlier previously adjudicated findings, even where the trust, the land steward trust of which Mr. Payne is a trustee, was the petitioner in the campground case, and he's a petitioner individually here. Offensive issue preclusion does not require mutuality of parties when the essential question having been finally adjudicated is against the party who is now seeking to be free from that finding, and that party had full and fair opportunity to litigate the issue in the first action. In this instance, as previously indicated, Ms. Sexton had ample and full opportunity to participate and make challenge to the 1971 and 1978 deeds, as well as the Payne's use of that central portion of lots 57 and 58 through the operation of the campground. Here again, where they're not disputing Ms. Irene Payne's use of lot 58 as a single family dwelling. When those facts are combined, the use on both lots together with the color of title deeds means that the land court in this instance did not err in determining that Payne had sufficiently established title by adverse possession under color of title under the same reasoning and facts that were applicable in the first campground case.
Do you agree that Judge Trombley addressed your argument regarding standing?
You know, Your Honor, I don't believe he did. We did challenge it at the time, and we challenged his finding at the time under Chapter 185, Section 38, which requires that anyone who files an objection, it forever bars anyone from filing an objection after the return date. We quoted that statute, and he found that because her purported partial interest in locus came after the return date, that statute was inapplicable. I note in our brief on this appeal that not only did she file her objection 11 years after the case was originally filed and 2 years after the return date, she did so. The reason she didn't file an objection prior is because she didn't even own or claim to own a percentage interest in locus until the week she filed her objection. Again, 11 years. So the argument that she didn't get notice is inapplicable because she wouldn't have gotten notice. She didn't hold title. I did want to know.
Do you agree that abuse of discretion is the standard we should apply to Judge Trombley's decision on that argument?
I would agree.
All right.
I do note that we fully briefed the substantive merits of this claim and are providing the standing argument because we've made it from the very, very beginning and do want to provide the context of how late she came into this game. I also want to note that her own title evidence has no bearing. I do dispute Mr. Schultz's assertion that the Slade study sketch is undisputed. We do dispute it. We are not claiming under Lot 6 or Lot 16 on that study sketch. That is wholly immaterial to our color of title claims, which are derived from the 1971 and the 1978 deeds that describe Lot 57 and 58 on the assessor's map. They have nothing to do with the study sketch. The court did not err in determining that her record title interest is irrelevant here because even if she did have 100% clear marketable title to this property, our adverse possession claim would take priority and we would still be declared the owner. And for all of these reasons, I'd respectfully request this panel to uphold the Wayne Court's decision. Thank you.
Thank you very much. Thank you both for your argument, counsel. It was helpful.
We are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good afternoon and welcome to today's session of the Massachusetts Appeals Court, which is coming to you via Zoom and also via YouTube. My name is Jeffrey Kinder. I am an Associate Justice of the Massachusetts Appeals Court, and I'm joined by Justice Eric Neyman and Justice Edward McDonough. We will be your panel for the case of John Doe number 36194 versus the Sex Offender Registry Board. Counsel, we will conduct today's hearing just as we would if we were in the courtroom, which, as you know, means each side will have 15 minutes. There is no rebuttal. We have read your briefs and the relevant portions of the record carefully, so I would urge you to get to the heart of your argument. So with that, I will turn to the appellant counsel, Mr. Gauthier. The floor is yours.
Good morning, Your Honor, and good morning, panel. My name is Edward Gauthier. I'm appearing today on behalf of the plaintiff appellant John Doe. And Mr. Doe was finally classified by the Sex Offender Registry Board as a level 2 sex offender. We are challenging the final judgment of the board and the judgment of the Superior Court denying our motion for judgment on the pleadings. Mr. Doe committed a single sex offense 34 years ago when he was 19 years of age. And the expert who testified at the hearing and who was credited by the hearing examiner stated emphatically that this was not a sex offense. Yes, it met the definition of a sex offense because we apply an elemental approach to determining whether something is a sex offense. However, there was no sexual motivation, and the plaintiff, Mr. Doe, suffers from no sexual deviancy. Now, the hearing
judge wasn't required, excuse me, Mr. Gauthier, the judge wasn't required to accept the expert testimony on that point, was he?
The judge is not necessarily required to accept expert testimony on a point, but in this case, there was no countervailing information or evidence presented to the board by the board counsel, and there was nothing in the record to suggest at all And I don't believe the hearing examiner made a specific finding that this was sexually motivated or that the plaintiff has, Mr. Doe has a sexual deviancy. I believe the hearing examiner accepted that this was a violent offense from 34 years ago, but that there's no ongoing deviancy. This is a case where the theoretical victim pool for Mr. Doe would be adult men. The victim in his sex offense from 34 years ago was a 30-year-old male. And if you look carefully at Mr. Doe's record, you can see that he's been incarcerated many times, and he's been in the community for many years. And presumably during that time, he has had unlimited access, both while incarcerated and in the community, to men who are 30 years old or about there. And in not one instance in the past 34 years has he been accused of, charged with, or convicted of sexually offending. We're not denying that Mr. Doe suffers from antisocial personality disorder, but as the expert stated, without any countervailing evidence from the board, having antisocial personality disorder by itself may indicate that Mr. Doe is a risk of reoffending generally. But given the fact that he committed a single sex offense 34 years ago, has had unlimited access to a victim pool for 34 years, and has not reoffended, indicates that he's simply not a risk of sexual reoffense. If he was a risk of sexual reoffense, he would have reoffended at some point. So we have a case here where he's been finally classified moderate risk. His name, face, biographical information is on the internet, and it's simply based on the fact that he's a criminal. I mean, if you have an opportunity to peruse his record or even take judicial notice of his record from the past year, he commits crimes. The court can take judicial notice of dockets in the Boston Municipal Court. He's been arraigned 10 times in the last 12 months, and he's currently held in the House of Corrections because he is a criminal. We are not denying that he commits crimes. However, based on the record in front of the board, Mr. Doe is simply not a sex offender. He is simply not a risk of sexual reoffense. His level should be 1. In reality, he should be relieved of his obligation to register, because I believe from the evidence presented to the board, it's pretty conclusive that he is going to continue to commit crimes, but he's not going to commit sexual offenses. And that's why the board exists.
Couldn't the judge reasonably infer just from the underlying facts of the governing offense that offense was sexual in nature?
There is no doubt that any offense that involves the genitals or areas that are private is by definition a sexual offense. A sexual offense is one defined by statute, and there is a statute, a like offense in Massachusetts of rape. And there's no doubt that Mr. Doe in this case committed the sexual offense of rape. However, there's no evidence that Mr. Doe was motivated by sexual desire or gratification. When we look at whether a particular offender who has been convicted will reoffend sexually, we have to look at what motivated their activity. Will Mr. Doe sexually reoffend? Well, if his only sex offense was not in any way motivated by sexual desires or gratification, if he's gone 34 years without committing a new sex offense, how can the board say that present day 2019, now 2020, that Mr. Doe is presently a moderate risk, whatever that might mean, of reoffending sexually based on an offense from 34 years ago that was violent in nature, but was in no way motivated by any sexual desire or gratification? Our argument is that the board can't do that.
Hold on, Justice McDonough appears to. There we go.
There we go. I'm sorry about that. Counsel, what's the basis for the determination that the offense 34 years ago of rape was not motivated by any sexual urges or desires?
Well, the testimony would be from the expert who evaluated the offense and evaluated the lifestyle of Mr. Doe during that time. In this case,
can you remind me of his finding or conclusion to that effect?
I believe that Dr. Plowd stated that Mr. Doe has no sexual condition, meaning he has no paraphilia or abnormal sexual interests in.
Are you speaking presently or 34 years ago?
Well, what matters is presently, but there's certainly no evidence from the past 34 years that Mr. Doe has any paraphilia or desire to have any type of sexual relations or sexual contact at all.
All right.
With adult men.
I thought you were representing that there was no sexual urge in connection with the offense, the rape he committed 34 years ago. Is your expert able to go back in time and make that opinion?
Well, number one, I would answer that no, the expert cannot go back in time to make that determination that there was no sexual motivation 34 years ago. But I would stress that the issue at bar isn't whether Mr. Doe was likely to reoffend 34 years ago. It's whether he's likely to reoffend now. And the board put forth very little evidence that at present, Mr. Doe is interested in sexually offending against what would be his group of interest, which would be adult men.
Mr. Gauthier, your expert, not your expert, but your client's expert, issued a report dated April 24th, 2015, which incorporated into the record. Was that report ever modified or updated?
It does not appear that it was modified or updated. From what happened was there were 3 hearings essentially. There was a first hearing.
I understand the procedural history of the case. I just want to make sure that we're still working off the April 24th, 2015 report.
Yes, we are.
Thank you.
Counsel, anything further?
If there are no further questions, the plaintiff appellant John Doe would rest on his brief.
All right, thank you, Mr. Gauthier. I see no further questions. Ms. Greenaway, when you're ready, the floor is yours.
Attorney Roxanne Greenaway for the board. Mr. Doe comes before the board having been convicted of forcibly sodomizing not only an adult male, but a mentally handicapped adult male, along with his co-defendant, where they sodomized him with a tree branch, causing him to have suffer tears to his rectum. So he committed this crime, and if you look at the case law, Justice Cordy in the concurring opinion in Doe 205-614 cautions the court on this very issue that counsel raises about looking at the sexual motivation of a crime. And he indicates in enacting the SWORD statute, the legislature was concerned with protecting vulnerable members of the community, especially children, from sexual predators of all types. Accordingly, the offenses enumerated in that statute include not only violent sex offenses, as we have here, but it also include other crimes that weren't sex crimes that are not violent sex offenses. And he indicates persons engaging in such conduct and posing a risk of doing so in the future, regardless of the motivation of their conduct, are as much a danger to children in the community as other forms of sexual predators. In this case, we don't have children, but what we do have is not only a vulnerable member of the community, but an extra vulnerable member of the community by virtue of his mental challenge. So you have an individual before you that has numerous regulatory factors applying based on the commission of that sex offense. Because that victim was a stranger he had just met. Factor 7 obviously applied, which goes not only to danger, but also to risk. You have that he was using alcohol and marijuana before he committed his sex offense. And on that point, when you look at the different factors that are all promulgated to determine current risk, not just past risk, while the factors may be based on past behavior, what you do have is that all of them look at current risk. So You have on factor 9 an individual that not only used drug and alcohol during the commission of this sex offense, he continued to do so while incarcerated. He continued to do so while in the community. And while in the community, he never stays out very long because he's always rearrested on something. So on the point where he hasn't been in the community so long and committing these sex offenses, he has not been in the community that long because he's always incarcerated. If you look on his record, from 2009, he starts getting committed from 1 year. And from my addition, cumulatively, he's sentenced to over 10 years in prison during that time. So from then to 2015, when he received his last sentence of 5 years to 5 years and a day, which is what he was serving when the board classification hearing was held.
As I understand it, your brother's not disputing anything you're saying right now. He agrees. He stated that the record is clear and that the petitioner is a criminal and continues to commit crimes. But Mr. Gauthier says, the record bears this out, that in the last 34 years, the petitioner has not had one sex offense or sexually related offense on his record. And there's no evidence of any crime that is sexual in nature at a minimum over the last 34 years. And therefore, at least for purposes of a SORB classification, a level 1 or a lack of registration, or sorry, a ruling that no registration should occur is actually the appropriate classification. What do you say to that?
Well, first, I would go to the opinion of his own expert that testified at the hearing. And if you look, that is in the record on page 44. And he says, after all the consideration of the same information that Your Honor just presented, that he should not be required to register at this time above a level 2 offender. So that's his own expert. In 2015, he wrote this report, indicated that. He then testified later at the board hearing years later and still indicated that he should not register higher than a level 2. So his own expert is also indicating that given all the information that Your Honor just indicated, he has not committed crimes in all those years, a sex crime in those years, that he still should not register higher than a level 2. Now, again, I make the point that all of the factors are designed to determine current risk, whether or not it's not just one thing. So when you look at all the factors that apply, and my brother does not dispute that the factors that are applied are incorrect, or that the hearing examiner made a mistake doing those. So when you look at those factors, which are what we're guided by, you come to the conclusion, in addition to, in consideration as well as to his expert's testimony, that he's a level 2 sex offender. So I would also just indicate to the court, if you look at DOE 496501, the court there goes through the difference of risk, danger, and the internet dissemination. And it talks about when you look at risk, you look at the risk that the offender will commit a new sex offense, not just general criminality, right? And then it talks about the degree of dangerousness. And this is where I want Your Honors to also take into consideration. It's measured by the severity and extent of harm that would result if the offender were to commit a new sex offense. And the type of—
I apologize for interrupting. Which DOE case are you quoting from?
496501. That's 482 Mass 643 2019.
Okay. Thank you.
You're welcome. And there it talks about you would consider, the hearing examiner would consider what type of sex crime the offender would likely commit if he or she were to reoffend. And generally, you look at the past offense. And what you have here for this particular individual, his past sex offense is not just a rape, as my brother indicated. It was the like violation is aggravated rape here in Massachusetts. In New York, it was first degree aggravated sexual abuse, which includes the insertion of a foreign object in the rectum of another and causing physical injury to the person by forcible compulsion. And those elements match aggravated rape here in Massachusetts. So this is not just a rape that we're talking about. This is aggravated rape. So that's what you would look at were he to commit another offense. And the victim pool would not only be adult males, it would be people who are mentally challenged, because that's the point of them being extra vulnerable. They are not able, they are more likely to be sexual assaulted than someone else. And when you look at the commission of the sex offense here, it's not only that that person was mentally challenged, they then physically bounded his hands and legs and gagged his mouth. So he was also physically vulnerable at that time. So these are the facts that you have to look at were he to commit another sex offense. And what you have is someone, again, that has continually used drugs, which are one of the elevating factors that one looks at. And you have him showing this behavior even while incarcerated. So he has not, again, been in the community for long periods of time. And even while he's incarcerated, he's still showing the same kind of behavior that precipitated, although not the cause of his sexual offense. So that's what the court must look at. And then, of course, with the internet dissemination, here we have a sexually violent contact, penetrative sex offense that, of course, the public has an interest in knowing that this person is amongst them. So based on those together, the confluence of all of those factors and considerations, I would ask that you uphold his level 2 classification.
Thank you, Ms. Greenway. Any further questions? Justice Neyman, Justice McDonough? Hearing none, I want to thank you both for your argument. It was helpful. The case is now submitted.